Thank you for everyone that's joining us for this, the last panel of the day. I appreciate that it's already been a very content-rich day one of the symposium, and so there's been a lot to absorb. Hopefully we'll give you a little bit more to absorb as well. Also very conscious that we're standing between you and your drinks this evening, so I promise I won't go over. We are tasked with talking to you today about settlement of global disputes. I'm very pleased to be joined on the stage today by the panel. I have at the far end Rory Spillman from Signature Litigation, next to him Scott Clare from Ancura, and next to him, next to me, Peter Janes from Shieldpay. What we're aiming to do today is to really bring together a number of different components that are imperative in the settlement process. We have the lawyer, as I mentioned, Rory, at the end there, who's really has the unenviable job, some would say, of negotiating the settlement, taking into account a multitude of considerations in the context of that settlement, dealing with the requirements and inputs of multiple stakeholders in that settlement negotiation process, increasingly now liaising with class reps, foundations, board members of foundations, advisory panels, and ultimately coming up with something that is going to achieve court approval. We have our expert. So the responsibility of Scott is to really drill into the heart of what that settlement looks like. So both at an aggregate level as well as on a per capita basis. Or maybe that's not even a monetary settlement. You know, there might be other elements to the settlement that still deliver reparations without it being monetary. But using, clever combination of economic analysis and financial modelling to really get to the magic number, which is often what the settlement is all about, Rory. And then claims administration piece. Obviously, that's where we come in as a claims administration business. We have to take the work of Rory and Scott and put that into some sort of practical implication. Thinking about how should these settlement terms be delivered, and how do we work out who should get a claim, who should have a valid claim, and who should get what amount of money. And that's in the context of sometimes sort of hybrid claimant classes as well, where you've got individuals and companies in the mix. So that all sort of fits into the piece that Rory and Scott do. And then ultimately, which is what we're all here about, is getting some money to some people that have been affected by a wrongdoing. And that's where Peter and the Shieldpay team come in being able to really, in a very efficient and innovative way, make sure that funds are delivered to class members or claimants in the quickest and easiest manner, and in a way that actually they will resonate with them based on the way they live their lives. So really that's why us four have come together, in the hope that we can talk a bit about those different components of a settlement process. So if I can just formally introduce my various panel members. So Rory is a partner in the specialist law firm Signature Litigation, has a focus on financial markets and complex multi-party international disputes. Rory acted for one of the lead claimant groups in the RBS rights issues litigation, which at the time was one of the largest opt-in group litigations in the English courts. The lead group represented by Signature Litigation was made up of institutional, corporate and retail claimants and pursued the case to the eve of the trial when it settled in the summer of 2017, if you can remember back then, Rory. Hopefully we've come a long way since then. Signature Litigation has experience in acting for both claimants and defendants in group litigation and class actions across their offices in London, Paris and Gibraltar. Over to Scott. Dr. Scott Clare is a Senior Managing Director and Leader of the Competition and Class Actions Practice at Ancura Consulting. Scott is an expert in economics, predictive analysis, mathematical modelling. He testifies regularly as an expert witness, including in class actions across many different industries, including energy, healthcare, environmental litigation. He holds a PhD in both industrial engineering and business administration, master's degrees in civil engineering and industrial engineering, and he's formerly a professor of UCLA's business school. Last but not least, Peter. Peter's the founder and CEO of Shieldpay, a cloud-based B2B payments business. Founded in 2016 and launched in 2018, Shieldpay is disrupting payment processing in B2B sectors, which previously could only offer a very archaic and expensive process to hold and disperse funds, coupled with a very poor user experience. The Shieldpay solution combines best-in-class digital customer verification, global escrow banking network, and a mass disbursement functionality to be the payment processor of choice for large industry sectors that really struggle with high-value, complex payments such as real estate, legal services, and supply chain. Shieldpay is now trusted by 40% of the top 100 UK law firms, entities such as White & Case, Shoesmiths, and McFarlane's, and has processed $5 billion worth of payments for customers all over the globe. Right, so formalities out the way. Let's start with you, Rory, because that's where it all begins in the context of settlement. What are some of the considerations when you find yourself at the table having that discussion?
Sure, thanks, Clare. Well, there's obviously a good number of considerations. We won't be able to cover them all off in 45 minutes. So I'll focus on a few and what I think are the key practical ones and ones that need to be considered actually much earlier than getting to the table, to be fair. But before I go on to those, it's probably worth noting that the considerations when contemplating settlement in terms of class actions, group actions, does depend on the jurisdiction in which you're pursuing your claim. For instance, we heard earlier that certain jurisdictions don't cater for pre-trial disclosure. Disclosure may assist in terms of settlement discussions. And certain jurisdictions may have particular avenues available that are not available in other jurisdictions. Similarly, it depends on the type of action being pursued. If it's consumer-based, then there may be other opportunities for consumer redress. Depends if it's financial services or product liability or competition claim. There may be other opportunities there. I think last year's panel spoke about the financial services case in the Tesco litigation and the fact that under the FCA's powers, Tesco's offered up a compensation scheme, and that obviously had to be taken into consideration for those particular claimants. There's also the distinction that's been discussed a lot today of opt-in and opt-out in relation to opt-in, at least in relation to the UK. There isn't many rules or regulations regarding settlements. It can be a very confidential party-to-party process. With that said, my experience is that if there is an opt-in structure and there is a settlement, the judge in charge will at least be interested to ensure that the settlement reached allows for clarity as to whether there is anything left on the table to ensure that the court resources can be addressed appropriately and that it avoids satellite litigation where possible. As on the other side, in terms of opt-out, obviously the one we've spoken about the most today is the collective proceedings order in the CAT. And opt-out in those circumstances does require, as you were saying, Clare, court approval. And that goes to whether the terms are just and reasonable, how the costs are dealt with, and also how the parties are going to communicate the settlement, give the parties opportunity to opt out, etc. As was mentioned earlier, there's also the fact that in relation to those opt-out proceedings in the CAT, there's the possibility in terms of a settlement of the defendants reclaiming some of the undistributed sums, which would be a big influence in terms of settlement or not. And there's also the possibility that a court may need to approve assessment of representative action, depending on whether the claimant, the class, can be ascertained or not. So there's quite a bit to consider there, just in terms of the jurisdiction you're in and the type of proceedings you're bringing. But as I say, I'll try and focus on a few of the practical points. And where I can, I will build on the experience I've had in relation to the RBS rights issue litigation. Obviously, I can't say too much in terms of the assessment of that. But as we go through some of the practical issues, I'll give at least some ideas of the things that we need to be considering. Not all of the points we'll list off today were relevant in that case. So I'll just very briefly summarise the RBS rights litigation for those who are not familiar with it. It was a claim brought by thousands of claimants in the UK in relation to the rights issue, RBS's rights issue in 2008. Unfortunately, the bank failed shortly after the rights issue. and required emergency assistance from the UK government. The claim was brought under Section 90 of the Financial Services Markets Act, and the claim was for losses in relation to what was said to be inaccurate or misleading statements in the prospectus or material omissions from the prospectus. It was structured as a group litigation order, which we've already heard about today. And due to the size and the complexity of the case, eventually there were 5 claimant groups, 3 of which were shared the responsibility of managing the case on a day-to-day basis through to trial. We represented one of those groups. The other 2 groups out of the 5 were follower groups, and their claims were involved, but they didn't have responsibility for the day-to-day management of the case. In terms of the group that we were advising, as Claire's already mentioned, we were the only group to have institutional, corporate and retail claimants, which of course brings with it a number of complications just in terms of the litigation itself, but also in relation to the settlement of the litigation. We were also the only group, I think, to claim against the bank as well as the former directors of the bank, which was another issue to consider in the context of settlement. In terms of settlements, 2 of the lead claimant groups, the other 2 lead claimant groups and 1 follower group settled in late 2016, which was months, if not weeks, before trial. A part of our group settled in early 2017. The remainder of the group pursued the case up to trial and settled just before trial. In fact, trial was postponed for, I think, a week or 2 whilst those settlement discussions were continuing. So a lot of settlement considerations there, which we can try and build upon to the extent I can talk about them today. In terms of the practical issues that I think are the most important, and as I say, are the ones that do need to be considered at the very beginning, the first one is the structure of the class or the group. I should say that most of these points I'm discussing were relating to opt-in, but I will touch on opt-out as well. In terms of the makeup of the group, that can impact how you address authority to settle, which I'll come on to in a minute, the level of settlements that would be acceptable to your particular group, and importantly, the way in which you communicate with your group. We've heard throughout today the importance of communication and reaching out to the members, which I'll also touch upon. And as I say, in terms of the rights issue litigation, our group was made up of 3 distinct subgroups, institutions, corporates, who were generally easier to communicate with than the retail claimants. In terms of the authority to settle, that's obviously key and needs to be structured from the very beginning. It's not just the ability to receive and potentially accept settlement, but it's also the ability to potentially make offers and obviously negotiate. It can be resolved in a number of ways. You can structure your claim in various ways in order to address it. We've already heard about the fact that claims can be assigned in full, which is a clean way of dealing with it. However, we've also heard today that assignments, particularly the SPV structures, are being challenged, and not all claims can be assigned. There's the ability to use powers of attorney, or just the assignment of the management claim itself to a representative steering committee, which may or may not have authority to settle, depending on the terms in which the management of the case has been delegated to that steering committee. I've also heard of, not seen, structures where there are drag-along and tag-along rights, effectively, so that the group stands and falls as one. And all of those points will need to be considered early on so that you're in the best place possible for those settlement discussions as and when they occur. The ability to communicate, as I said, has already been mentioned a lot today, and it is very important in terms of settlement discussions for opt-in purposes anyway. It can act as an alternative. You don't need to delegate authority to settle if there are good communication lines. The 2 issues with communication of settlements is really, 1, confidentiality. Obviously, you need to make sure that the lines of communication are as confidential as possible. Any leak could ruin the chances of settlements and also preclude further negotiations. And also the speed settlement is usually time of the essence. So you need to be able to not only communicate with your group or your class quickly, but you also need to be able to receive communications quickly and process them, particularly, for instance, if your group is structured in such a way that you need to have a sufficient level of acceptance of an offer before you can confirm to the other side. And equally, as again we've heard more today, communication is important for opt-out claims as well. We've heard about the rate in which settlements and claims are accepted, and that applies here as well. And there's certainly a place where technology can assist us, and there's been a vast evolution in the use of technology over the last few years in that space, particularly in the UK. It's already in existence in the US. Another point to consider, which is related to the points I've already discussed, is giving the other side, the defendants, and the court confidence in terms of what the settlement means. And what I mean by that is ensuring that you know who is being settled with and what is left on the table in that respect. And so it's therefore important to be able to give clarity with respect to the 2 points I've just discussed, authority and communication, but also it's important to ensure that there's clarity with respect to the quantum and the size of the group. Any settlement discussions are only going to be as good as the value that can be attributed to that particular group. And as I say, the defendants are going to want to ensure that they are very clear with respect to who they're settling with, who they're not settling with, and the value at which they're settling, so they know what risks are being left on the table. And I think that's why it's important to not only deal with the things that I've already spoken about early on, but also to bring in experts early on to ensure that you're very clear in terms of, and the use of technology, so that you're very clear as to the identity of your group, but also in terms of the mechanisms through which you intend to value your particular claim. And I think we heard this morning a big emphasis on bringing in the experts early, and I agree with that. Another important factor to consider connected to all of the above is the integrity of the group. In terms of opt-in, at least, as we all know, the book builds can be quite a frantic time, and are generally always working up to some form of limitation period. So it's quite possible, I think we heard it earlier, the fact that you could end up having Mickey Mouse in your group, and Mickey Mouse doesn't necessarily exist. Similarly, it could be the claimant unwittingly joins 2 different groups. And due to the fact that there isn't generally transparency in relation to those groups until a later stage in terms of the book building process, it may be that those issues cannot be resolved early on, and that could preclude settlement early on. So something also to be considering. One other point to consider, which is not necessarily one whilst you're sitting at the settlement table, it's one to be taken into consideration the whole way through, which is the settlement risk where there are multiple claimant groups. I think we can all see that this area is getting busier and it's becoming more competitive, so we're probably going to be seeing more and more class actions, particularly in the opt-in areas where there's more than one claimant group represented by different law firms. And that can be an advantage to claimants. The claimant groups can work together, they can share the workload, they can share responsibility for obtaining funding, and they can share responsibility for the costs associated with that as well. But it can be a disadvantage, or at least create additional risk in terms of settlement, particularly if one group settles and the others don't. And as I mentioned in the intro, in relation to the RBS rights issue litigation, that is what happens. 2 lead groups settled in late 16, shortly before trial, and that left our group as the remaining lead group with a decision as to what to do. As you can imagine, it was a fairly frantic time. We needed to consider whether we could keep pursuing the case all the way through to trial. If so, in what form? It raised questions in respect to funding, it raised questions in relation to ATE, and it raised questions with respect to resources. As it happens, we were able to pursue the case through to trial, and as I said earlier, it was settled just before trial. But that may not necessarily have been the case. So you do need to consider at that point, well, a lot earlier, I should say, how that can be prevented, whether that be by agreeing within the GLO a particular structure, if that happens or not. Just a couple of other practical points before I give it back to yourself, Clare, on the panel. I think we've already mentioned the fact that you may require court approval, particularly in the class, the CAT, the UK CAT, and the collective proceedings orders. You'll therefore need to have an eye to what would be acceptable to the court in that respect. And finally, it's already been touched upon quite a few times today, I'm sure it will again on this panel, which is the form of compensation and the affecting of settlements. Non-monetary compensation, I think this was touched upon at last year's panel as well, may not necessarily be the best thing in circumstances where the courts the claimants will need to address the cost of the litigation. There are ways around that in terms of structuring settlements in order to address those points, but they do need to be considered. Equally, as we've heard today, it's not all about the money. There's also the pursuit of governance changes or changing the way particular big firms do things. But on the other side of that, there's the cost of distributing out the various monies, and we've heard today, and we'll go on to hear, that there is, thankfully, processes in place and technology in place that makes that a lot quicker, more efficient, and less costly, which means more going to ultimately to the claimants, which can only be a good thing.
Thank you, Rory. That's really interesting, and really interesting to see it, think of it from the practical point of view. There's practical points to take into account. You touched on the role of experts and how you actually value these claims. So that leads us quite nicely onto you, Scott. I mean, I imagine the way in which you approach your analysis and valuation of these claims differs vastly across the subject matter. So it's quite a broad sort of area to speak towards. But give us a few more insights into how what that process looks like.
So well, let me start with a couple things. First of all, our starting point in terms of doing that sort of evaluation, it's always the same. And that starting point is to think along the lines of who are what's the exposed population? You know, if it's product liability or whatever it is, what's the overall potential class size? And then we think about, okay, of that, what percentage of them were actually affected? And of them, what percentage are likely to be involved or opt in or be part of a class? And then we get to the dollars amount, which is damages or what sort of payment would be appropriate. So that's the way we start thinking about it. And then we immediately throw that out the window, because literally every type of case is very different. I mean, overall, let me say this. I think class actions are, well, first of all, they're very important. There's a lot of money involved. There's a lot of people involved. And then there's also the opportunity to the effect that it affects how firms behave towards their competitors, their customers, the general public, the environment. So it's important. It's also, do you know what? It's really interesting. And it's really difficult. The estimations that we do are difficult conceptually. For example, right now, a huge issue is how do we put a monetary value, a damages value on privacy? Okay, I mean, that's a rhetorical question. I don't have an answer at this point, and a lot of people in this room are thinking along those lines. It's difficult computationally. We routinely deal with hundreds of millions of records related to bank transactions or people working. And it's very difficult methodologically. One of the things that's interesting exciting to me is that we come up with new methodologies because we're forced to come to very practical viewpoints on how are we going to pay people, what's the right amount, and kind of how do the pieces fit together. An example of this is some years ago I was involved in a class action filed in the United States related to EU Regulation 261 that says that if you're delayed on airlines by reasons that are not weather-related, equipment-related, then you should be compensated if it's more than 3 hours. So we sat there and we had 100 million records of flight legs that people had taken. And the question is, how can we come up with some sort of algorithm that tells us which of these legs resulted in the person being delayed more than 3 hours with these other reasons excluded? So I think that's kind of a broad overview of it's important and it's difficult. But when we get to settlements, those things apply, but that's a point in the litigation where there's some history. Nobody settles large class action lawsuits without doing a lot of advanced work. Now, sometimes if we look to the prior stages of the litigation, probably more often in the UK and the EU than in the United States, starts with an initial assessment A financial assessment, now from the plaintiff side, you might think of it as it's the opportunity related to the case, and from the defendant side, it's the risk related to the case. But sometimes it's rough estimate, level of magnitude kind of estimate of what's it worth. Then there's the sort of the first stage of the more formal litigation process. And by the way, this is all from the economist's perspective. There's whole lots of legal stuff going on that I'm not involved in and know nothing about. The class certification. For economists in the United States, and there's some problems with this, the class certification stage is where economists spend more time, more effort, and more billings than almost anywhere else. And if you saw the last panel, they very appropriately, they're talking about this, it's an academic, statistical, theoretical exercise. It can feel very abstract, even though it's for a very specific purpose of essentially trying to come up with an assessment of whether the class and the data, whether the class members are appropriately homogeneous, that class action treatment is appropriate. Well, the next stage is then full-on trial for damages and liability and a round of expert testimony, and I guess I don't have anything to say about that because I've literally never experienced it, and it seems to very rarely happen. And that's because in the United States, following class certification is a very natural time for the settlement to occur. Everybody's cards are on the table. Both sides can say, here's how strong the case is. Nobody wants to take it to the next step, which is full-on trial, because of the risk and money and time and PR associated with it. So that's kind of history. We're sitting there. We've done a lot of analysis in the past. Some of it is very academic and theoretical, but the settlement process is fundamentally a very practical issue. Again, there's a lot of legal stuff that has nothing to do with me. From an economist's perspective, there's an intense focus on two different things. One is claimant by claimant, how are they going to get paid in very specific terms? Because what you have to do is you have to write an algorithm, a recipe, that unambiguously shows who gets what, right? And then at the very other end, you're intensely focused on what's the total amount of money involved? Because it's a pretty big question and of great interest to whoever's writing the check and who's ever receiving the check. And to a large degree, the economist's job is to link those two together. And let me give you an example that was, you may have heard of, it was a few years ago now, there was a large class action lawsuit related to concussions in the National Football League, so American football. Former National Football League players that had played for a few years, a lot of years, had retired. And the question was, how are we going to pay these people, compensate these people, when they come down in the future with cognitive impairments in different categories? And the attorneys on both sides were sitting down day by day, and they're negotiating out a payment matrix. Someone would get this much money if they're diagnosed with early onset Alzheimer's at age 50 and they'd played in the league for so many years, for example. And that's a pretty complicated recipe for how much you're going to pay people. But now the big question is, what's the total amount of money involved? So this was our job as the economists, is to forecast out how many of these former players will come down with cognitive impairment, when will that occur, what type will it occur, and when in time will it occur, because all that determines, take all those projections and roll them back to today and say, here's how much money that's going to cost you in terms of today's check. So that's largely our role in settlement, is to connect those two dots. And then if we advance to settlement administration, we have a similar role, which is to say, settlements can take a long time. They can take a long time. Is to say, well, what's coming next? Here we are economically in this settlement. We've paid out so much. How much is left to go? And a huge reason that's important is because that tells us how much we can pay people who have not yet made a claim. Maybe the best example of this is we're very involved in asbestos claims in the United States. And this has been going on for decades now, of people that come down with asbestos-related impairments, and they make claims against trusts that are established. And one of the things my firm does is we do, every month, every quarter, we do projections of how much is left to come. So how do we do this? we have, on the one hand, we have this recipe claimant by claimant. Here's how much money they might get if they appear, and then we want to aggregate all those together. And every time we do that, it's different because it depends on the specific circumstances. It depends on what data we have. It depends on whether we have to predict the future or if we already have a good understanding of well-defined class. Our starting point is to say, all right, is there history we can rely on? Because we're always trying to take some benchmark and extrapolate that into the future. It starts with, is there some history we can rely on? That's what we do in asbestos. We look at the history of claims, we extrapolate that into the future with adjustments for things like how many people have died. If that's not available, we look to outside resources. We look to other industries. We look to similar circumstances to see if there's a benchmark. And then in some cases, we have to perform a statistical analysis ourselves. And for example, in this National Football League's case, we developed a computer simulation methodology that looked into the future. So we wrote our own silver crystal ball to predict the future.
Wow, can it do any more than just that? Or can it tell us all what the future looks like? I just want to pick up on one point. You talked about data, right? And we always talk about data-driven approach and how data is invaluable in this sort of analysis. Typically, where do you find that data comes from? Is it homegrown data? Is it from the other side? Is it from the claimants themselves? Is it a mishmash of all of it?
It just depends.
Right.
There's often, we rely very heavily when it's available and appropriate on data from the client, from the defendant. In the airline case, for example, we relied almost entirely on data from the defendant.
Yeah.
In other cases, we're relying much more on data from the claims that we have received to date.
Yeah.
And then we recognize, look, this is partial data. It's not not representative of overall what we would get, but it's the information that we have, and now we think about how do we take that data and project it into the future, adjust as necessary for, say, class members that are claimants that haven't yet appeared.
Okay, thank you. I think we might be all slightly disappointed that you haven't given us a definitive answer to the value of privacy, but you can be forgiven for that.
I'm working on
it. Right, so moving on to you, Peter. So tell us more about exactly how do you get this money to the people or the institutions or the businesses that it need to receive it, and how do you do that in the most quickest, efficient manner, and in a way that maintains the reputation of class actions and collective actions, because I think that's something that those of us that are outside of those jurisdictions that have an established regime, we're very keen to find a way to best promote the benefits of this mechanism, both in the UK and continental Europe, and make it swift as well. And so I think there's a lot that you do at Shieldpay that sort of ticks a lot of those boxes. So tell us more about that.
Well, firstly, thanks for having us. A bit of a potted history of how this all started. It's back in 2016, we sat down with two sets of regulators, one being the FCA, the other being the Solicitors Regulatory Authority, to try and come up with a way or an alternative for lawyers not to have to handle client monies anymore. So back in 2016, and it's gotten a lot worse since then, as a lot of law firms are actually struggling to get insured because using very manual ways of working meant that they were often unfortunately, the victims of a lot of cybercrime, and obviously with cybercrime increasing, insurance premiums were increasing. And so now there's actually huge swathes of the legal industry, such as conveyancing, where the actual underlying conveyancer is really struggling to get insured. And it's simply they were doing it because there wasn't an alternative. So all of the payment incumbents that you all know, PayPal, Stripe, Adyen, Venmo in the States, they're not regulated in a way to hold client funds. They're what are called straight-through processors. So the hypothesis was that if a payments business was available that was regulated to a very high standard that could hold funds on behalf of clients, would law firms trust a third party to do that? And so we started that journey in 2016, and early on the answer was, you're a nice to have. And we started to build up a reputation, started to do a lot of case studies to show what the technology could do. So in 2018, we did the first fully digital mortgage anywhere in the world that we know of in 2018, and started to prove that we can handle these sums of money, because one of the hardest things with being a fintech is getting the underlying client to trust you with their money, and that's difficult with $5. Our average transaction size is sort of £100,000, $120,000. The reputation that you have to earn took 4 years. And to be honest, it moved from being a nice to have to a must have because of COVID. So manual ways of working that law firms were adopting to process funds, 4-eye checking documents, moving paper around the room, very expensive lawyers manually signing off, AML, KYC, that all broke in a period of about 3 months. So huge increase in inbounds to us, because I think what people have realized is that the benefits of doing it yourself, the benefits of outsourcing it to somebody else, outweigh doing it themselves. So, we started within what we call corporate payments, so paying agent roles, M&A, commercial real estate transactions. But we started to realize and started to speak to good people like yourselves that there was actually a role for Shieldpay within class actions, because it's so onerous. And had conversations even today about the lengths that the underlying law firm has to go to get the funds out of the door. The amount of backwards and forwards that needs to go to validate these people are who they say they are. It's the right bank account. And so we've sort of stepped in as a viable alternative to law firms or administration platforms having to do this themselves. So our first journey into this world was last September, which was an airline data breach. And that was, as far as we know, the first time open banking had ever been used in litigation services. And it was really pleasant to watch sort of come through the reviews and the metrics that we have of the speed of which we could get the funds to people who really needed it. So for that particular one, we knew that the underlying law firm, it would have taken them about 2.5 months to process that, to onboard that many people, to go backwards and forwards, all the exception rates. And now we managed to do that in about 17 hours. And it's just nice seeing that. And so it's nice having a very nice part of this ecosystem where we're not getting involved in the legalities. There's a lot of clever people out there that do that, but think of Shieldpay as the final mile where, in its rawest form, we can receive a batch file from the law firm, and we take it on from there. We use very smart digital tools like bank verification tools, open banking tools, to match the claimants to the bank accounts that they're providing, for example, which sounds simple, but the amount of backward and forward to see if that is actually the person who they say they are. And as we talk to the back, some of these cases, unfortunately, a lot of these people aren't alive anymore. And so there's also a number of tools that we can utilize for that. So it's essentially, we are slowly becoming the trusted third-party payment provider for this type of activity.
Fantastic. And to touch on something you said there about the demographics of claimants and class, and how you have to be sensitive to that when you're deciding how to get money to them and get money to them quickly. Sure. I'm just going to speak towards the UK slightly here, Scott, so forgive me momentarily. But obviously, we are going through a rapid transformation in the UK as far as the collective actions are concerned, and that's both with regard to opt-out and opt-in, I think. I think there are actually some radical changes being made with regard to opt-in as well. We've got Caller now, we're seeing claimant firms starting to actually collaborate on these cases. We're seeing claimant firms actually starting to work together to make sure they haven't got duplicative claims going over to the defendant. So really building sort of a more robust claimant bar, I guess, in that respect. And then in parallel to that, we've got everything that's happening in the CAT, and we are slowly but surely moving towards, a day we hope we all see in the future where there could be a settlement in the CAT. I think our case, the Mishcon BT case, is listed for trial early 2024. So, we could well be here this time next year, maybe, even maybe not doing so much stargazing. But all of that comes with a lot of challenges, right? So us as a claims administrator this year, we've had to deal with, giving notice to a class that includes deceased, giving notice to a hybrid class that's both consumers and businesses in the McLaren Maritime Shippers case, in addition to what Walter mentioned this morning about, you know, at the last minute having the defendants reach out directly to class members and almost suggest to them that opting out might be a good idea, and then us having to deal with that because that, you know, it had a spike in opt-outs, etc. So, you know, that I think that just demonstrates how you have to keep on your toes, you have to be innovative, you have to keep thinking of solutions. If we can do a little bit of stargazing, because, you know, we've all been talking about what's happened to date, what do we think in the context of settlement, what do we think are going to be the biggest challenges to getting some settlements over the line, both in the UK and, if we want to touch on continental Europe as well at the same time, for the foreseeable? Does anyone have thoughts on that?
I mean, I can start. I mean, I guess in the UK we're obviously many decades behind the US in terms of maturity of it, but we're sort of seeing many more claims with much larger pools of people, and obviously from a settlement point of view, from an administration of that, it makes it 10 times harder to do that, and obviously validating all the information and the data sets. So I think that's going to be the challenge, is you're doing much more of them more often, and things, unfortunately, with manual processes, they break. And so, yeah, from a stargazing point of view...
Volume.
So it's you know, being innovative, you've got to sort of react and create a technology that can service that type of volume. Mm-hmm. So that's ultimately where the innovation has to happen, in terms of the data and supplying it and processing it.
Yeah, I agree with that, and I think that the more that people like Shieldpay can do what they do, it leaves the lawyers to deal with the more complicated areas in terms of distributions, whether it be because people have passed away and things like that, dealing with estates and probate, because inevitably that will happen in these class actions. That's just life, unfortunately. But the more that can be dealt with in a very much more efficient way means that you can get to those more complicated issues more quickly, which hopefully means more getting paid out more efficiently.
You know, I'll say I see, coming from the United States here, I see an industry that's sort of searching where to go, and it's chaotic. And I think it'll converge to something. Mm-hmm. I hope it'll converge to something that is informed by but corrects some of the things of the U.S. system that aren't awesome.
There's so much for us to learn there. Yeah.
Right, and one thing that comes up is, as I said, the amount of effort that goes into class certification stage in the United States almost overshadows so much of the rest of the litigation, in a way that, okay, it leads to a lot of billable hours by economists, but it isn't necessarily it's not the ideal situation.
And I'm going to ask you a slightly controversial question, Rory, I think. I talked at the beginning about how you have to consider lots of different stakeholders in the context of a settlement, and those stakeholders aren't just your clients. Mm. So what is the role of funders, AT insurers, advisory panels, LMA committees? You know, how does all that work in the context of a settlement, especially if you have a differing opinion within that, and how do you navigate your way through them in order to reach somewhere which means you can actually get to a settlement? Sure.
Well, I think a lot of that is dealt with by dealing with it early on, in terms of ensuring that there's clarity as to where the authority is to settle. But just assuming for your question that the authority still sits with the claimants in question, and they all each have their own elements. Unfortunately, I think it is a case of the solicitors listening to all views. And I think, actually, to be fair, in the RBS case, for us, whilst there was issues to deal with because of our makeup of group of institutional, corporate, retail, the advantage was it did give us a diverse view. It gave us a 360 view of the case and the merits of it and the values of it. For instance, there would be retail claimants out there that just wanted to see the case go to trial. It didn't really matter in terms of assessment. And you have to have those conversations with the various committees, representatives that are within the group. But they do have a place. They do need to have their voice depending on the structure you have. And then you do have to go between them and find the right route for the group as a whole. As I mentioned, in terms of our group, there was a portion that settled in early 2017 and a portion that could continue to pursue the case. And in terms of funders, they may or may not have terms in their funding agreements as to what should happen in particular circumstances, and if there's a disagreement, then one of the usual clauses that I've seen before is that it would go to a KC opinion or QC opinion for the purposes of assessing that particular settlement offer, if there is one.
Interesting. There's a lot going on there then, a lot of people to think about.
Indeed, yeah.
And thinking about the sort of global elements of settlements, we see this all the time. The same defendant, the same subject matter, the same wrongdoing, settling out in some jurisdictions, notably the US, but not exclusively the US, and then not settling in other jurisdictions, or settlements happening at a far later stage in other jurisdictions. And I guess, Scott, this is slightly for you, but also for other panel members. I guess when you're conducting your analysis on a case, albeit that it may be in the context of a US class action, it's immediately apparent to you from your analysis that there's a far wider exposure beyond the one that's being dealt with in the US court. What are your thoughts, and I'll gather the whole panel, on why that happens? What are the parameters or the drivers that lead to this situation where we're not actually achieving global settlement? I mean, we're talking about settlement of global disputes, right? But we're not actually talking about global settlement because that don't happen.
Okay, so to unpack that a little bit, okay, why does it happen? It's because they're different jurisdictions, different economies, different rules at play, and it's just different settings overall. So the reason why it happened is really, I think, that straightforward. It also comes down to, within a particular lawsuit, not everyone acts the same way or is treated. For example, some defendants may settle out because it's in their best interests, and the plaintiff side accepts that and wants their settle to help fund the rest of litigation. So some of it is almost random behavior. What we do in our analysis is, in some cases, that element is very important to us because in that, say, preliminary financial analysis, really what we're trying to do is mimic. We're trying to anticipate what will happen in the legal system. And if legal system is different, we'll come up with different answers. But then in other parts of our analysis, when we're saying, okay, what are damages? In a very rigorous way. We're saying, what are damages in the sense of how would somebody's circumstances be different if the alleged bad act had not happened? That is pretty venue agnostic. And it would, so the different venues would have very limited effect on that.
Yeah, I agree. I think to some degree it will depend on the rules and regulations in particular jurisdictions. I mentioned earlier, and it was mentioned before this panel, about the fact that in the CATs and the collective proceedings orders, that there is the opportunity for defendants to obtain back some of the undistributed sums that will play into considerations as to settlements, and that may not be available in other jurisdictions, for instance.
I think one thing we've started to see in the UK at least, and hopefully that will trickle through to other European jurisdictions as well, is an appetite for some defendants to settle early in a private settle arrangement, especially in the context of institutional investment claims, shareholder class actions, but not exclusively. We get approached and speak to defendants about private settlements as well. Peter, first of all, actually, let's turn to you. Has Shieldpay been approached by defendants yet? Is that on the table? Is that a discussion that's being had, or do you think that's a little way down the line?
I think it's a little way down the line. I think we're still proving, I guess, our worth to the industry. We've done a number of really interesting ones, the airline data breach, the online ticket marketplace, and there's some whoppers coming down the line which have very much an international flavour to them. So I think it's more, it's resonating with the certain section of the industry. But I think it's make the efficiencies that we bring act for both sides. So ultimately it will become much more a talking point within the defendant side. But at the moment it's, we're still sort of 11 months into this journey, but we're expecting it to come, yes.
Hopefully, right?
Yeah.
I think that's an important topic. And taking off my economist hat and putting on my business hat, a basic notion of business is when you have a problem, you want to get ahead of it. And this is what you're talking about.
Yeah.
Let's get it behind us. In that NFL lawsuit, I mean, that's where it was. The NFL wanted to be back in the business of making money. And so it was a PR nightmare. Yeah. And the players wanted to get it settled so that they could, because they had problems related to causation in a court of law. And it drove a fairly early settlement.
Yeah. Growing trend, hopefully. I think that wraps up what we wanted to say today. I'm going to ask if there's any questions out there, although there haven't been any questions all day, so I'd be amazed if anyone's going to ask one now at the risk of delaying drinks. But if there are any, no? Well, in that case, all that remains is for me to thank the audience, thank my esteemed panel members, thank you for your time, and thank you to the organisers for looking after us today.
Thank you very much.